Kỹ thuật ơi, bật hộ em mấy cái mic này lên nữa. Right. Okay. Okay, good afternoon, everyone. Welcome back to the 15th South China Sea International Conference hosted by the Diplomatic Academy of Vietnam. And per traditions, we usually dedicate one sessions to, legal affairs, the legal dimensions of the South China Sea issues. And today, our sessions, number 4, title, Must There Be a Law on Lawfare, will play such role. And our pleasure is to have His Excellency, Mr. Andrew Goled-Cizanowski, the Australian ambassador to Vietnam, to chair the sessions. So take it away, Ambassador.
Xin chào, good afternoon. At every international conference, there's one boring session. I'd like to thank you all for participating. It's an honor for me to be invited back to moderate, and it's a great pleasure for Australia to continue to support this important international conference. I have the honor now to introduce you to our 4 distinguished panelists. Starting on my right, online, we have Professor J. Batong Bakal from the Institute for Maritime Affairs and Law of the Sea at the University of the Philippines. On my left is Professor Robert McLaughlin from the College of Law at the Australian National University. On his left is Professor Antonios Tsanakopoulos from the University of Oxford. And finally, but not least, is Professor Ian Chiang Chung from the Dalian Maritime University in China, and who has kindly agreed to also be addressed as Gavin. After a brief discussion with my panelists, they've allowed me as moderator just to say a few words about the definition of lawfare, because it's not entirely obvious, even for someone like myself with a legal background. I think at its simplest, it could just mean the use of international law for national objectives. But I would put to you that the better view, probably, and the one suggested to us by the abstract in our program, is that it should properly be understood as the misuse or abuse of international principles in order to undermine international law. Although all of that also is in the eye of the beholder. So the question then is posed to us by the program and by the organizers, if indeed there is this phenomenon of misuse or abuse of international law, do we need a framework of laws to manage lawfare? So I invite our first speaker, Professor Jay from the Philippines, to address us on this subject or anything else that he would like to say. Jay, over to you.
Thank you, Ambassador, Excellencies, friends and colleagues, good afternoon. Thank you for allowing me to participate only virtually in this conference, although I would have really preferred to be there in person, but as you know, certain things get in the way. I would have loved the chance to catch up with friends and colleagues at this annual conference. The topic, of course, is lawfare, and I've entitled my presentation as 21st Century Lawfare, Some Considerations for the South China Sea. Given that there is a timer ticking on my screen, I will abbreviate my presentation a bit and let us jump basically to the fifth slide, please. The Secretariat can please jump to the slide number 5. Again, taking off also from the definition of lawfare. Lawfare is in international law and relations has a very different context. And even though certain forms might also make use of the legal process, no, as we contemplate it in this discussion, we're talking about lawfare as basically a weapon of war, a means of realizing a military objective. Would the Secretariat please go to the next slide and the next slide as well? One more slide. Okay, so here we're talking about exploitation of law, and including whether it's perceived or even orchestrated incidents of the law or violations as employed as unconventional means of confronting a superior military power. Okay, so there is that particular purpose which defines it as lawfare. Next slide, please. So lawfare has received a great attention of late on account of some states resorting to its various forms as a means of gaining unwarranted advantages in interstate relations. So the abuse of international law, as already referred to. And this is to lend a color of legality to an otherwise illegitimate conduct. And particularly in the era of today, after the establishment of the United Nations, with its aspirations of outlawing open warfare and the use of force, this gains particular relevance for us. Unfortunately, some states openly embrace the use of lawfare as an integral component of their national military doctrines and strategies for gaining control of a contested arena or a situation in pursuit of their national objectives. So one of the more documented examples is the underlying doctrine of the People's Liberation Army, for example, and by extension, People's Republic of China. China's military doctrine and academic literature speaks of lawfare as one of the so-called three warfares of PRC military strategy. And it is one of the three means of influencing and controlling perceptions, especially those of the adversary, which is critical to advancing interests in peacetime and objectives in wartime. So simply stated, it is through the use of law and legal instruments that the adversary's range of actions and responses are restricted. The very ability to think through and counter actions is undermined, weakening their defenses and creating initiative and advantage for the offensive. Okay, next slide, please. So even the US has recognized this as a method now. The US Indo-PACOM has accepted the need to address lawfare as an area of competition. So they define lawfare as well. This definition brings to the surface this arena and challenge, no? That lawfare poses. It defines it as the purposeful use of law to achieve a particular strategic, operational, or tactical objective against a particular adversary, or to bolster the legitimacy of one's own and thereby weaken the adversary's strategic, operational, and tactical objectives. So in the first instance, that is the use of law itself as a weapon. And in the second one, it is the use of law to support other means or weapons, perhaps. Okay, so in either case, lawfare is perceived as an adjunct of military strategy and warfare undertaken in the preparatory stages or phases of a competition short of armed conflict. It presents the advantage of enabling the accomplishment of objectives without the use of kinetic actions, winning the war without fighting, so to speak. So that is what we're looking at now. Next slide, please. In the South China Sea, every day we now see the PRC, for example, employing lawfare visibly and overtly despite the illegitimacy of certain actions. Lawfare is used in both principal and supporting roles here. The enactment and unilateral enforcement of the China Coast Guard law against Philippine government vessels, particularly the Philippine Coast Guard and the Philippine Navy, as they carry out their legitimate activities on Ayungin or Second Thomas Shoal, a submerged feature that is not subject to illegal territorial claims and indubitably part of the Philippine EEZ and continental shelf. China deploys its maritime law enforcement and militia forces against Philippine patrol and resupply vessels, which are exercising legitimate rights and jurisdictions under the UN Convention on the Law of the Sea, as validated by the South China Sea Arbitration Award. We see China's employment of lawfare in its principal aspect when it insists on its claim to sovereignty over the open sea, seeks to apply Chinese law against sovereign immune vessels of another state, use an overwhelming array of potential coercive force to make another government act in a way that it does not want. And China uses lawfare as well in a supporting and supplemental role when it attempts to justify these actions through official statements and statements of its media, describing this part of South China Sea as being part of their sovereign territory, invoking Chinese law to portray Philippine activities and actions in its EEZ as illegal, and glossing over its use of provocative and dangerous maneuvers in violation of basic good seamanship to set up situations for collisions between smaller Philippine vessels and their much larger Coast Guard and militia ships. The China Coast Guard particularly shows its true colors here in the South China Sea, where it appears to be not a maritime safety agency, but a provocateur and instrument for creating maritime hazards. Next slide, please. So, from China's actions here, in this particular sample, we can derive some observations. Simply stated, China's lawfare in the South China Sea is stark evidence of the emergence of modern colonialism and imperialism. Regardless of the absence of the overt use of force, China's unilateral imposition and attempt to carry out enforcement against the sovereign immune vessels and agents of another state clearly violate the underlying principles of the United Nations Charter, which embodies the principles of respect for sovereignty and sovereign equality among all nations, big and small. China's attempts to enforce its laws against the Philippines, exercising its legitimate rights and entitlements to marine resources allocated by international law, are nothing less than an attempt to subordinate and subjugate the Philippines. It is the modern version of political and legal domination by a colonizer over the colonized. Its demand for its own national interests to prevail and preempt those of smaller neighbors is today's version of political and legal domination by the colonizer over the colonized. It's often repeated accusation of the Philippines as a mere puppet of the United States, as if a country with a population of over 110 million cannot have its own independent views and interests in today's complex world, smacks of a colonial mindset that disrespects the existence of sovereign peoples. Its reference to spurious and revised historical facts and justification for special preemptive rights echo the rationalizations of old European colonial powers, such as Spain's claimed mission of evangelization in the name of Christianity, or Great Britain's claimed benevolence for bringing civilization back then. China's need to secure marine resources that legally belong to other countries under the terms of a multilateral convention that it itself signed and ratified, but now seeks an exemption from, on the basis of its excessive and expansive claims, is nothing more than a modern version of practices and policies of exploitative colonialism that peaked in the 18th and 19th centuries. Its offers of development aid under agreements that largely benefit itself, such as the generation of employment for expatriate Chinese workers, burdensome interest of Chinese loans, exclusive choice of contractors, leaving the supposed beneficiaries with the burden of loan repayments and without assurances of the economic viability of development projects, are the modern methods of creating economic dependence and institutionalizing inequality. So the use of lawfare here is not exclusive to the Philippines. It's also employed systematically against every other Southeast Asian country for the sake of advancing China's excessive and expansive claims. It seeks to influence other countries and international institutions to accept the superiority of its status and merely watch as it takes away the legal rights and entitlements of smaller neighbors. China's lawfare, therefore, is nothing less than the pursuit of an imperialist enterprise, a modern imperialism with Chinese characteristics. Next slide, please. So what then are the implications of this lawfare to the South China Sea Code of Conduct negotiations, a significant norm-making exercise that has been dragging on for a quarter of a century? These rights protection activities of China, the lawfare that it continues to employ, by which it seeks to enforce excessive claims on the strength of domestic legislation, the China Coast Guard law, against not only civilians, but particularly government vessels and personnel of other countries, fall within the various definitions of lawfare. And the active conduct of lawfare is inherently inconsistent with the holding of talks to settle disputes through the creation of norms and rules. It is incompatible with sincerity and undermines confidence in negotiations which should be free of coercion. So the continued lawfare will color the COC negotiations and tend to show that the participation in negotiations are mere distraction intended to cover up other actions, which will always give rise to questions about its good faith and intentions. So to conclude, with the last slide, please, I believe that the burden now rests with the smaller, independent and sovereign nations of Southeast Asia. That burden is great and clear, especially for claimant states. It is important for claimant states to resist this lawfare, this imposition of unilaterally established laws and rules that preempt their legitimate interests under international law. They can do this by calling out such lawfare tactics and describing it truly to and the inherent threat to secure compliance and submission. Southeast must learn the lessons of the regional front against the threat poses to their autonomy and independence of states. Especially Clause Tennessee Arbitration Award provides the principal frameworks for an equitable allocation and distribution of the sea and its resources, and provides the means and mandates for cooperation between states on equitable terms. Southeast Asian claimant states must band together and counter this colonial and imperialist enterprise and uphold international law and the South China Sea arbitration, because that is the best option they have for protecting their autonomy and independence. Thank you very much.
Well, this may not be the boring session after all. Professor, thank you very much for your presentation and for keeping to time, even though I think I stole the first 3 minutes of your period. Your satellite link was breaking up just a little bit in the very last minute, but I think we got everything that you intended us to hear. I will now move on to the second speaker, and I invite my compatriot, Professor Robert, to come to the podium.
How about now? Oh, yes. All right. Better not use my big Navy voice. Good afternoon, and can I first thank the DAV for the very kind invitation to come to this year's conference. This is the first time we've been able to come in person, and it's so much better than having to present online as we did during COVID. The second thing I'd like to do is thank the ambassador for his very concise framing of the problem, and I tend to agree. One of the issues is there is no specific definition of lawfare, and really lawfare depends on the eye of the beholder, depends on what you're talking about. So I do thank Jay for laying the groundwork on what lawfare means in this particular context. The third thing I'd say initially is that it's a great honour to be on this panel with these distinguished colleagues, including Jay. And then I will briefly focus on the session theme element of Pacta Sunt Servanda. See if I can make this work. Okay, so what I would like to talk about today is briefly what are the concepts we're talking about. As a lawyer, of course, you want to know what are the left and rights of arc of a concept, what are the definitional aspects, what rules go into understanding, interpreting and applying the concepts. I'm not going to spend too much time on lawfare, but I will briefly look at how lawfare and the grey zone differ, because I think that's an important point for us to think about. And I'll briefly describe what is the doctrine or the maxim of Pacta Sunt Servanda. Then I'd like to look briefly at how Pacta Sunt Servanda can be used in lawfare. And I guess the point I would make at the outset is that Pacta Sunt Servanda can be as equally used to combat lawfare as it can be used to facilitate lawfare. And I think there are two dimensions to that, which I'll talk about in a moment, which is Pacta, which is differing views of which law applies, and the other is the Servanda, which is the performance of the rule, and there are differing approaches to how you can exploit savanda to achieve a lawfare purpose. So the next point is to describe our key concepts. I'm not going to talk in too much detail about lawfare. Jay has very well laid the groundwork there. The first thing I'd say is that pacta sunt servanda, pacta means rule or treaty in our case here, sunt, and servanda, to be obeyed or to be performed. So this is the maxim that we're talking about. You can immediately see that there's two aspects to this and there's two dimensions or two levels. The first is pacta. What is the applicable rule? And so you can see the lawfare utility here of having, if you want to achieve your aim, potentially a nefarious aim or an illegitimate aim, one way you can try and give it the veneer of legal legitimacy, as Jay mentioned, is to actually argue that a different rule applies. The other is servanda, and that's how the rule is performed. And the key issue in servanda, which I'll talk about in more detail in a moment, is that it has two aspects. There's a methodological aspect, that is how you apply the rule, and there is a content aspect, that is what is the content of the rule that is relevant to the weighing or balancing approach that you go through in order to assess how the rule applies. But more importantly, how are lawfare and the grey zone different? The key here is, I think that, as Jay explained, lawfare is about the law. So lawfare is bound by the rules of law. It relies on the definitions inherent in the law and all of that paraphernalia that goes with law as a concept. The grey zone is not a legal concept. And I'll put my cards on the table right away. There is no law of lawfare. There is no law of the grey zone. There is the law of peace, which includes very tense peace, and there is the law of war. There's no third paradigm in the middle where there's a different set of rules that apply to the so-called grey zone. So lawfare is a tool, but only one of the many tools that is used in grey zone operations. Grey zone operations use other tools like misinformation, disinformation, obscuring the identity or the status of particular actors. Those are all grey zone tools. Lawfare is but one tool that is used in the grey zone toolbox. But that does not mean that the grey zone creates its own law. The grey zone exploits existing law to achieve or give the veneer of legal legitimacy to a particular outcome that is being sought by that particular actor. It doesn't mean that when the law is applied in the grey zone, the content of the law changes. The law is the law. It doesn't shift as a matter of law just because I'm now looking at it in the so-called grey zone. So, as I mentioned briefly, how does pacta sunt servanda serve? So pacta sunt servanda has two elements. One, the pacta, what is the agreed law to the servanda? Briefly, how do you use pacta in lawfare? Well, you use pacta in lawfare, or you lawfare-ise pacta by claiming that the rule set or the rule that applies to a particular situation is not the one that your adversary is claiming. And that allows you then to shift the dynamics, to avoid an inconvenient rule, and to say that some other rule applies, which then gives your assertion of a different rule to achieve your specific purpose. It gives that assertion a degree of legal legitimacy. So that's how pacta sort of works. The more interesting one, I think, is servanda. How does servanda work? The rule performance issue. And I was going to look at an example of due regard in the EEZ, but I'm not going to dig into the example too much because I want to save a minute or so at the end to address some issues that came out of the second panel today. But in brief, the servanda approach to lawfare exploits two things about servanda. One is method. Okay, so how do you apply the rule? How is the balancing conduct that you engage in order to work out how the rule applies in a particular situation to be done in that unique, as may be argued, situation? One example that you'll see in relation to the EEZ obligation of due regard is a claim by some scholars and some states that there is a not explained requirement of appropriateness. when balancing the military activity state or the intelligence, security and reconnaissance performing state with the EEZ coastal state. This idea is not in the Law of the Sea Convention EEZ due regard obligations. There is an obligation to balance, but the Law of the Sea Convention sets out the parameters of that balancing act, which is contained within the Law of the Sea Convention. So that's a methodological approach to lawfare. The second approach is content. And the most common place that we see this is where states or individuals, commentators will assert that there's a whole nother set of rule content that needs to be considered because of the specific situation. And when you're talking about security in the EEZ or non-interference and those sorts of things, when you're trying to weigh this up against the EEZ due regard obligation, this is the importation of extraneous rule sets that should not be incorporated into that assessment process. But when you do want to change the outcome of the assessment in your favour, one way to do it is to say, well, the performance of this rule and the content of this rule is different in this situation because of some issue, such as security. So that's really the essence of what I wanted to talk about in my brief time in relation to Pacta Sunt Servanda. I'd like to just finish with a couple of comments on some things that came out of the second panel today, and I suspect some of my colleague panelists might want to say something as well. Look, there are a couple of comments on the second panel that talked about, I'll be honest, it sounded to me like the irrelevance or the discardability of international law based on balance of power shifts, for example, or that a rule became inconvenient for a particular power purpose that a state or a rising state or any state might wish to pursue. And this, I think, needs to be challenged. First, the purposes of international law, there are many purposes of international law, but the ones that might be, or some of the ones that might be relevant to this situation is, yes, international law is inherently political. No international lawyer will argue with that point. But international law within that context serves several purposes. One is, it is the language of framing disputes. So if you throw out the international law, you throw out your ability to dig into and frame a dispute accurately at the outset. Two, it provides dispute resolution mechanisms that are designed to help resolve or freeze a dispute or a contest without resort to serious force. Okay? Three, international law provides a level of predictability to state relationships and, importantly, to reactions. So these are three of the purposes of international law that we need to think about if we're talking about the discardability of international law or a particular rule set. So from that, I would make just four final points. One, international law is actually born in crisis. That's how international law develops. International law evolves due to crisis. So to say that it's not suited to crisis is completely the opposite end of the stick. Two, therefore, international law exists precisely to help put boundaries around crises, and in particular around systemic upheaval. And so to say that international law needs to be jettisoned, or a particular important constitutional rule set needs to be jettisoned because there is some sort of systemic upheaval, is exactly the wrong way to approach it. Third, international law does have inbuilt evolutionary measures. It has mechanisms that allow the law to evolve, not rapidly necessarily, but nonetheless to evolve. And it has those inbuilt measures precisely to mitigate and manage systemic challenge. Finally, if you dispense with the language of international law and the mechanisms of international law, how do you frame the dispute adequately? So the law is meant to be inconvenient sometimes, and it's meant to be inconvenient exactly to preserve predictability and stability. So we sometimes need to respect the inconvenience because it actually serves a systemic purpose. Thank you.
Thank you, Robert. Again, bang on time. You gave a few minutes back even. Thanks very much. Those were some useful reminders, actually, about why we have international law and why it's best respected. Moving right along, I'd like to invite Professor Antonios to make his way to the podium and say a few words.
Thank you. Thank you very much. I'd like to thank on my part as well the Diplomatic Academy for having invited me here. It's first time in this conference, first time in Vietnam, first time for everything. So after the thanks, I would like to apologize for not having a PowerPoint presentation. Apparently everybody's taking pictures of the nice presentations being shown with all the ships flying around. I'd rather you take pictures of me instead, so please feel free. Now, there has been, as Rob said, there has been some framing of the idea, and I have to resist the temptation of trying to define it for myself. And I can try, but I'll fail. And so here's what I would say about lawfare at the outset. And that is, so we heard the reference to undermining the law. It's just of using the law to undermine the law. It's a slight problem with that, especially in international law, and that's that undermining the law makes the new law, because that's the way international law works. You could easily say that President Truman undermined the law of the sea by declaring that the United States have exclusive rights over the continental shelf. He was taking over parts of the high seas. And through this undermining of the law, a new concept of law emerged. So this is the problem with lawfare. The problem with lawfare is that everything can be termed as lawfare. So we heard Jay at the outset talking about how China is waging lawfare on the Philippines and various other states. And with respect, and just to piss everyone off today, I can easily say the same thing about the Philippines, nicely packaging and shoehorning a very, very broad dispute into a particular question that it could then fit into the UN Law of the Sea Convention, so that it could then use the compulsory dispute settlement of that convention, so that it can then bring it to a tribunal, which it could get a decision from to then use for political purposes, among other things. I'm not saying I agree with that. I'm just saying you could easily frame it that way. And so this is where we have a problem, because you could say that lawfare itself, the use of the term lawfare itself is lawfare. To try and sort of show how this works, I will take a particular example, and that's the understanding of archipelagic states, the definition of archipelagic states, and the regulation of archipelagic states in the Law of the Sea Convention, and try to see whether we can lawfare it in a way. And I'm not going to connect it specifically to claims of states that have been made, but I'm sure you know that there are claims of states that have been made in that respect in the South China Sea. So what am I going to do? First of all, I'm going to introduce archipelago and the archipelagic states, also because I'm Greek by descent, so I have to give you some Greek definitions, and talk about the Aegean Sea in the middle of the South China Sea, because why not? And then I will also try to show the arguments about going beyond the Law of the Sea Convention, beyond the regulation of archipelagic states in the Law of the Sea Convention, with respect to what is sometimes called offshore archipelagos or outlying archipelagos. And then discuss relevant arguments for that. For example, that the Law of the Sea Convention doesn't actually cover outlying archipelagos, so this still remains to be covered by customary law. Or if the Law of the Sea Convention covers them, subsequent practice of the parties has led to an agreed definition, to an agreed interpretation of the convention that covers outlying archipelagos. Or if that is not the case, then perhaps there is supervening custom after the Law of the Sea Convention that actually supervenes the relevant regulation. And then I will try to connect it back to lawfare, if I may. So this will be rather quick, obviously, because the time is running out, but archipelago, originally meaning the principal sea. The idea was the Aegean Sea, an area of sea dotted with islands that basically constitutes some sort of unity. Now, interestingly, the Law of the Sea Convention defines archipelagos and archipelagic states in exactly the opposite way. That means it does not allow states with continental territory to qualify as archipelagic states. It only allows states that are completely made up of islands to be characterized as archipelagic states, and it then gives some significant powers to those states, like, for example, the power to draw archipelagic baselines around the outermost islands and project zones from those islands, so from those baselines. So you can imagine that, or in fact, you know, because you come from the Philippines or Fiji or something like that, you can then project quite important zones from that area. Now, the question is, did the Law of the Sea Convention exclude the possibility of an outlying archipelago and applying these rules to an outlying archipelago for a state with continental territory? Because an argument can be made and has been made that, look, the Law of the Sea Convention only covers archipelagic states in that definition, but you can have an outlying archipelago and still you could apply the same rules to it. That is, draw archipelagic baselines or some sort of baseline around it and project zones from there. Now, this argument has a number of problems and can be responded to in a number of ways. The first one is to say, look at the travaux, look at the discussion in the third conference, UN Conference on the Law of the Sea, where quite clearly that issue was put. There were a number of states, including Greece, that did want continental states to be able to have archipelagic status, and they failed. So it was sort of dealt with and rejected. But that's not the only argument. The Law of the Sea Convention is a package deal. It was negotiated as a take it or leave it instrument. In fact, it was negotiated for more than 9 years for that reason. And so it was meant to cover the field. So there's no argument that can be made that actually, well, they didn't regulate outlying archipelagos, so that remains to be regulated by customary law. More importantly, the outcome, the principle of effectiveness in interpretation would tell us that interpreting the Law of the Sea Convention as not having dealt with archipelagos, with outlying archipelagos, would actually render the whole regulation of Part 4, the whole regulation on archipelagos, redundant, because in fact, you would be better off claiming an outlying archipelago than you would be claiming an archipelagic status under the Law of the Sea Convention, because the Law of the Sea Convention comes with limitations. It comes with land to water ratios. It comes with maximum extent of the straight baselines, of the archipelagic baselines that you can draw. It comes with particular status of the waters landward of the archipelagic baselines, which are internal waters, but to which a particular regime of passage applies, which is far more relaxed than innocent passage, and so on and so forth. So that wouldn't make sense. But even if you could go beyond that, and you could say, well, okay, let's accept that the Law of the Sea Convention has dealt with outlying archipelagos and has rejected them, or at least did so in 1982, there's nothing stopping subsequent practice from having evolved in that connection. And in fact, there are continental states that claim something like archipelagic status for outlying archipelagos. The response to that would be very quickly that that needs to be in the application of the convention. And the problem here is that none of these states have actually told us specifically what is the status of the baselines that they draw. Are they Article 7 baselines? Are they Article 47 baselines? What is the status of the waters that they claim? The landward lying waters, is that internal waters? Is that internal waters with a right of innocent passage? Is it internal waters with a right of something akin to transit passage, or an equivalent of archipelagic lane passage, and so on and so forth? So that practice doesn't qualify. But even if it did, it would need to establish the agreement of all parties to the convention that that particular practice has become now the accepted interpretation. And the problem is that it has been objected to. And once it's been objected to, it can no longer qualify, according to the International Law Commission, as subsequent practice in that sense, a subsequent practice that establishes the agreement of parties as to interpretation. But even if that is not the case, then you could argue that since 1982, okay, there is no subsequent practice, but a new customary rule has emerged that supervenes the UN Convention on the Law of the Sea on that matter. I mean, it is possible. And of course, there are also answers to that. And the answers to that are similar to those, or the objections to that are similar to those with respect to subsequent practice. Well, where's the opinio juris? Where's the legal claim? You haven't told us anything about the status of the strait baselines. You haven't told us anything about the status of the waters. How could this be the case? But also, supervening custom does not actually mean that the relevant part of the convention all of a sudden is disused. It just means that there is a good faith obligation to renegotiate, which would be quite a different thing from claiming, oh, a new customary rule has emerged, and so we're in the clear. Now, why did I say all this? First of all, because I think archipelagos are very interesting, but also because it is a good example of lawfare, or potential lawfare, whatever that means. And I'm also going to refer, like Rob did, to some things that were heard earlier. There is nothing inherently valuable in the way that this matter is dealt with in the Law of the Sea Convention, to refer to the comments made in panel 2. Nothing inherently valuable about this law. It's just an arrangement, a reflection of power and of horse trading during the negotiation of the convention. And indeed, it can be cast aside if all parties, in fact, at will. It can be cast aside at will. I mean, if you don't believe it, look at what happened to Part 11 of the UN Convention on the Law of the Sea with respect to the international seabed, right? It was negotiated, it was put in the convention, and then all of the Western states were like, man, that's kind of too communist for us, so we might not do that. So let's cast it aside by adopting an implementing agreement, except it doesn't implement, but it completely changes the convention. So of course you can cast it aside at will. The question is whose will? Time's up. Okay. At the same time, just let me give the other side. The UN Convention on the Law of the Sea may be like a sausage. It may have intentional ambiguities, but in some areas it is not ambiguous. It is not ambiguous at all. In fact, it is perhaps arbitrary, because that's the trade-off, right? You either make an ambiguous rule that is not arbitrary, or you make a perfectly non-ambiguous rule that is completely arbitrary, like you can all vote at 18. That's not ambiguous, but it's very arbitrary. Archipelago is a tough area in which to wage lawfare in that sense, because precisely because of the very strong legal arguments against outlining archipelago. So you should have picked a different area. I mean, take a leaf out of the investment lawyers book and just argue on the basis of fair and equitable treatment. You'll never lose. You can do whatever you want there. That's very ambiguous. So there is a law on lawfare, is what I'm trying to say. We don't need to create one. We already have a law on lawfare, and it is called the law. Thank you.
Well, thank you, Antonios, for reminding us that undermining the law can lead to new law, although I assume that was an observation rather than a recommendation. And thank you also for saying the word archipelago with a perfect Greek accent. I now invite Professor Ian Chiang, Gavin, to perhaps capture all the thoughts that have been picked up so far in this session and bring some of your own ideas and finally resolve the question that we've been asked. Okay. Thank you, Gavin.
Thank you, Ambassador. Thank you for having me here. The topic I'm going to talk about is legal basis for Chinese ships navigating in the South China Sea. The reason why I pick up this topic is that Chinese ships has been constantly accusing intervening easy of coastal stay around China Sea without any reason. And the other reason is that Chinese Coast Guard has been using some kind of illegal force to against the ships from other states. So those are the criticism we receive. But my question is that, as a researcher myself, as a legal scholar myself, is it true? Those so-called the Chinese ship have no legal basis when navigating in South China Sea. So bearing those questions in mind, I then turn to the question, turn to the question that teased out by one of our participants from the floor. Whether or not China has the right, have the legal basis to navigate in South China Sea. So hopefully by the end of my presentation, I will provide some answer for the question from the floor. So basically, when we are talking about the navigation right, different type of ship are subject to different rights of navigation in both international and domestic law. And basically, we can differentiate ships from different category. For example, official ships and private ships. For official ships, including warships and law enforcement ships like Coast Guard. And particularly, I would like to mention some scientific research ships that are operating by the government, and that is also included in the official ships. For private ships, including fishing ships, merchant ships, and the private owned scientific research ships. So those are the category of different ships from China. China is the party to UNCLOS, SOLAS, Courageous, MARPOS, and STCW, all those international conventions. So China is subject to transpose all those international obligations into its domestic level. There's no doubt about that. So if we look at international law, for UNCLOS, those provisions are subject to apply to all Chinese private ships. There's no doubt about that. On the other hand, UNCLOS grants China certain jurisdiction over the navigation in its ship beyond its territorial waters. For example, if ships infringe the custom or sanitary laws, and China has a jurisdiction over it. So for Courageous, during the navigation, private ships are required to comply with the traffic separation arrangement for coastal state within the jurisdiction. There is no doubt about that. And for SOLAS, this is regarding rescue and research services. It means that coastal state have the right to apply a specific requirement for foreign ships in their waters under specific circumstances, including certain restriction on navigation rights of foreign ships. And if Chinese ships are operating outside of Chinese territorial water under the jurisdiction of South China Sea coastal state, and it is required to comply with those requirements. And for the MARPOS, private ships must comply with the provision to prevent pollution from any maritime area. And there was a newly emerged issue regarding Fukushima nuclear contaminated water, that issue. There was one issue that is not mentioned by the audience or not mentioned by the participants today, is the ship's ballast water. This issue has not been dealt with by MARPO and not dealt with by any of the convention around the world. So it is really, I would like to draw your attention on this nuclear contaminated water. In particular, ships carry this ballast water. Those so-called ship ballast water may in some way speed up the will in some way speed up the contaminated water spread around the world. So it is really worrying situation at the moment. So for navigation regime of preparation in SWCT, the Chinese ship is the crew of the ship are negotiated in the maritime area under its jurisdiction does not meet the requirement of marine amendment are subject to comply with this restriction. So let's quickly go to the state practice. If you look at state practice in South China Sea, Vietnam has the rule that require warships need to notify the competent Vietnamese authority before they enter the territorial sea. Whereas the Philippines actually say that if you did not strictly comply with our requirement, you are required to leave our territorial sea. And for Indonesia, they are completely banned nuclear related ship enter its water. Whereas in Malaysia, it does not impose any restriction in the innocent passage of warship and governmental ships. So let me quickly jump to the fourth part, which will be the domestic legal basis for Chinese ship sailing in the South China Sea. There are a number of national legislation that relate to navigation, including territorial sea and contiguous zone law and EEZ law. And earlier I mentioned maritime traffic safety law and Coast Guard law. Those are law related to navigation. If you look at territorial sea law, we'll realize that China is required for warships and governmental ships to notify Chinese authority before they enter into Chinese territorial sea. And that is pretty much the same like Vietnam. For EEZ, that's freedom of navigation. There's no doubt about that. So if you look at the navigation regime of private ship under the Coast Guard law, Coast Guard law actually require the Coast Guard has the right to require a ship stop and change course if they suspect some criminal activity. And also Coast Guard law at various levels, they have the right to set up so-called temporary warning zone in the maritime area under the jurisdiction. So I would suspect people from the audience will raise a lot of questions about this warning zone, but I will leave that part for Q&A. And lastly, the Coast Guard has the right to restrain navigation of ships suspected of violation of law while being investigated. So that is something from the Coast Guard law. And for the regime of navigation, navigation regime for private ships in the maritime safety law. Maritime safety law is the primary legal basis for navigation rules for private ship in maritime area under China's jurisdiction. Therefore, private ship in China must strictly comply with the provision of maritime traffic safety law during their navigation in the South China Sea. And there's no doubt about that. And that including accepting inspection, suspension of competing authority and comply with arrangement made by competent authority for traffic safety. And according to the law, its general provision and law emphasize that the scope of application is limited to water under jurisdiction of China and does not have extraterritorial effects. So basically, that is what happened to the private ship. So let's look at the what happened to the public ships. So according to Article 56, a public service ships may be exempt from the restriction of the relevant rules and of navigation, berthing, and operating on the permission of ensuring maritime traffic safety. So that basically that is a rule applied to the official ships. So for the navigation regime of official ship in the Coast Guard law, the Coast Guard enforcement ships itself also belong to category of official ships. So Coast Guard law clarify the enforcement authority and scope of the Coast Guard enforcement ships through legislation. So in the process of law enforcement, the Coast Guard may impose restriction on navigation rights of other type of ships, including other official ships. So in summary, Chinese ships should exercise their navigation rights in accordance with domestic law and the restriction while strictly distinguishing maritime area under Chinese domestic legislation and those beyond it. And Chinese ships navigating in domestic waters should comply with provision of domestic legislation, including maritime traffic safety law and Coast Guard law, and should not be restrained by foreign competent authority. So basically, that is the legal basis I have found for Chinese ships navigating in the South China Sea. And that concludes my talk today. Thank you.
Thank you, Professor. That was very clear. We now have moved into the Q&A period. I hope that there are lots of questions. I hope some come from lawyers and some come from non-lawyers. And I'm going to take the moderator's prerogative to ask the first question, which I think is particularly directed to Robert, but anyone can answer it. The Warner Brothers movie Barbie was banned here in Vietnam famously because of showing a 9 or I think it was an 8-dash line. My question is it reasonable to actually say that Margot Robbie and Ryan Gosling were involved in grey zone operations, wittingly or unwittingly? I'm going to just leave that one there for now and take a few more questions from the floor, and then we will go to the panel. Yes, sir, in the third row.
Thank you, Chair, and thank you, panelists, for your interesting presentations. And I have 2 questions. First one is to Professor Robert McLaughlin. And in fact, I do not understand very well your presentation, but one thing is usually in principle, when a domestic law is is contradict to international law, so people need to apply the international law that the country is a party. So how can we talk about warfare and in this case? And I have another question to Professor Yan Chang. You talk about the law, the maritime law of Vietnam, but we have another law. That is a law of treaty. The law of treaty stated that if a domestic law is against international treaty, that Vietnam is a party, except Constitution applies the international treaty. So it means that the maritime law of Vietnam is not against UNCLOS. If it's against UNCLOS, so applies the UNCLOS. It does not have any contradiction as you cited. So I have a question. Usually, I heard that old cases relating to China that people criticize, relating to China violation of international law, especially UNCLOS. So what do you explain in this case? For Vietnam case, we totally follow the international law, UNCLOS. Yes, thank you.
Thank you. I'd like to invite another question or two before we go to the panel. Yes, Greg.
anybody on the panel who might have thoughts. Professor Yen gave us a breakdown of rules governing public and state-owned vessels. How would one think about the legal status, obligations, and rights then of particularly the professional militia vessels, those from Sancha City, owned and operated by a state-owned company, and who are clearly conducting public enterprises, whether that's law enforcement or rights protection or whatever we call it? Are those state vessels, or are they private vessels that could be treated as simply illegal actors?
Okay, I'll take one more. The gentleman on the right, sir.
Thank you so much. Just again, Andre from the ICRC. Professor McLaughlin, the position stated is supported very much from our perspective that the law is clear, and I just thought I would flag that and say we very much value that view, because the protections given by the law, international humanitarian law in particular, is very important for the ICRC. There's a clear threshold. If an armed conflict erupts, then international humanitarian law is applicable, of course, meeting the requirements. If not, then it is not. But frequently we find that the term gray zone is used as a reference to say, well, the law is unclear. And I think that's just something I want to flag and support, I think, in terms of what you said. And I think some of the other speakers also referred to that it's important to clarify that the law, hard won very much, international humanitarian law, through blood, sweat and tears, shouldn't be undermined loosely by saying the law is unclear. Yet frequently there are factual situations that are possible of being interpreted in different ways. And I'm framing that as a background to what I want to say. And I think what I want to say is we very much encourage this kind of event, this kind of dialogue, where we can talk about these incidents and clarify what the consequences are, not because the legal framework is unclear, because we debate about frequently the factual situation or the implications thereof. And maybe not so much a question as just a remark to say we strongly encourage states to continue talking about this, to continue engaging dialogue, especially with the ICRC where it is at all impossible or where it is required by states, but also for states to keep engaging on this, so that the protections given by the law is immediately activated and recognized, and so that the victims of any kind of violence, be it armed conflict or other violence, is not prejudiced by those protections not being activated where they are due. So just wanted to say that and support that, and really encourage states to keep talking about that and clarifying those issues, not because the law is unclear, but because we debate when certain provisions are activated. And that's frequently a factual question, and not so much a question on the law. Thank you.
Thank you for that comment, Andre. I see a couple of more hands, but we'll go back to the panelists now and maybe come back for a second round. Jay, I wonder if you'd like to jump in on any of those points, or would you like to see these panelists here go first?
Oh, perhaps the panelists can go ahead. I'm having some issues here. Sorry.
Okay, please go ahead.
And my internet keeps winking out.
At the moment, we've got you. So do you want to go now, or do you want to go next?
I'll go next.
Okay, terrific. So who would like to jump in? Okay. Robert.
So 4 questions, and I guess all of my panelists will have answers to all 4 questions. First one, Barbie, grey zone operation. Yes, or an accident, I'm not sure. Second, domestic law being contrary to international law as a mechanism of lawfare. Yes, it depends where you stand, I think, because there are canons of interpretation and incorporation into domestic law. I'm not going to, the approach in international law is always, of course, that international law needs to comply. That domestic law, national law needs to comply with international law. That is 100% clear in international law. Does that mean that states don't sometimes implement them in different ways? No, but there are two types of difference. One is where a state implements international law that is completely, implements a domestic law that is completely contrary to international law. Every state has done that, my own state included. No state is immune from that, having done that at some stage. But the second one, which is trickier, is that just using different words or expressing a point or a principle from international law in your domestic law differently isn't necessarily an inconsistency. And the example I would give is that when my country, Australia, incorporated the Rome Statute, International Criminal Court offences into our national law, we had to change the way we express levels of criminal responsibility. So it doesn't reflect exactly what's in the Rome Statute because we have a whole corpus of domestic criminal law which approaches criminal responsibility in a different way. It doesn't mean it's inconsistent. It just means it looks different. Greg, your point. I'll give you my answer. It might be a bit controversial, but I think that the maritime militia, especially the Sanchez City militia, are state vessels. As a consequence, I don't think they commit piracy, but I do think that their conduct is attributable to the PRC, and that conduct then needs to be assessed in accordance with the rules on state responsibility. Under the law of naval warfare, in my humble view, the Sanchez City militia are targets. Andre, I of course, in relation to international humanitarian law, I could not agree more. And sometimes the law is not clear. In IHL, most of it is clear. Sometimes aspects of the law are not clear. And I mean, Antonius was, yeah, that's right. I mean, proportionality is one of the ones in IHL that creates some issues. But the great thing about international law is that there are canons of interpretation. There is a mechanism for how we get at clarity. That doesn't mean we always get there, but one of the great things about international law is that it does have a mechanism for achieving clarity. It might take decades, but nonetheless it works.
Antonius.
Thank you. Yeah, thanks. I'm generally covered by what Rob said, but very quickly and taking it from you can't say the law is clear or unclear. I mean, that's what I tried to say. There are certain things that are clear. So maybe threshold for international armed conflict. Yeah, that's relatively clear. Very few will disagree with that. And of course, I understand from the perspective of the ICRC, this is what you need to say, and I'm all for it and with you. But of course, there are very many rules of the law of armed conflict that are anything but clear. And if you want a current example, you can look at Middle East. And that's where the problem is. And that in a way also connects to that question about the relationship between domestic law and international law, which is very problematic. And I agree with Rob, but what I would like to say is it depends on the rule, right? If we're talking about something like, can I apply Chinese law or Filipino law or Vietnamese law in this particular zone? Well, the question is that zone determined in accordance with international law? States will disagree with that. What are the powers of the state in that zone? And there, the powers, so you have to look at the law, and that's mainly, in general terms, it's mainly permissive. So it permits a particular area of jurisdiction that you can't go beyond as long as you stay as long as you stay within this jurisdictional space that is accorded to you by the international legal rule. You can provide for whatever you want. Right? You can't, you have to respect certain limitations, but you have an area of discretion which you are fully capable of using, including by not exercising jurisdiction, by not legislating, by not enforcing what you've legislated, and so on and so forth in certain circumstances. So we have to be a little bit more specific in order to be able to say that. And then with respect very quickly to, I also consider them state vessels. What I would say in that respect, just to make it clear, is that doesn't mean they don't have to comply with domestic law if they are in an area where the coastal state can prescribe and enforce its law. The only thing that happens with respect to state vessels, warships, and so on and so forth is that they're immune. So in that sense, it can't be enforced against, but their actions being attributable to the state, if they are also in breach of an international obligation of that state, the obligation to respect particular law that the other state has the right to prescribe in that area, then the state becomes responsible. And that's a very complicated way of saying Rob was right.
Antonio. Professor Ian Chung.
Okay, let me quickly respond the law of treaty issues. Law of treaty, UNCLOS is a product of compromise. So they do have some kind of space or for coastal state to regulate, depends on its particular situation. And that is perhaps something reflected in Chinese domestic law, and so as Vietnamese, and so as Filipino domestic law as well. So I do agree with Robert just say, it doesn't have to be exactly the same expression like UNCLOS. It has to have some kind of space for coastal state to regulate on its own discretion. So that's something I want to say in the first place. And on the other hand, apart from UNCLOS, China is a member to IMO. So earlier I present quite a number of international treaties that is actually under the IMO framework as a level party to IMO. Quite a number of treaty is really directly transposed into its supervene Chinese domestic law. It doesn't have to be really regulated at domestic level. China has to comply with that. So that's the second response I would like to provide to you. And regarding the private enterprise scientific research ships, it really depends on the purpose of that scientific research, and also depend on the budget for that public enterprise. If the budget is from public authority over 50%, and I would say that activity is really considered as the public authority activity rather than private enterprise activity. So, and the other judgment or the other standard to justify would be the purpose of scientific research. If the scientific research is for the general common good, and I would say that is more or less like a common heritage of mankind, and you don't need to argue with that. But again, if the scientific research activity is mainly served for governmental purpose or military purpose, then I would say that would be something that need to comply with UNCLOS. That's my response. Thank you.
Okay, thank you. Professor Jay, would you like to come in?
Yes, thank you. Sorry, I was trying to orient myself. Some loss of internet there. But with respect to the first member of our audience on the issue of domestic laws being contrary to UNCLOS, I agree with Rob and our other panelists. Now, it depends first and foremost on the content of the domestic law and the international law that is alleged to be contravening it. There's an issue of first determining whether it is really contradictory or for some say violation of international law, because as we know, law is about language as well, and language will determine the degree to which there is non-conformity or even contravention. Then there's also the issue of the nature of the international law that is involved. There are conventions and treaties which simply set standards, and then allow the states to be the ones to implement and establish in the domestic sphere how those standards are going to look like. So the compatibility and implement whether it's and also whether the domestic law is actually an attempt to implement the particular rule of law is something that we need to look at. So it really depends on content. That being said, there is of course the general rule in the Vienna Convention on the Law of Treaties that you cannot invoke domestic obligations to avoid compliance with international obligations. So we have to see whether that particular rule is involved whenever you're looking at a domestic rule, a domestic law, and an alleged, a related international law. I missed most of what Greg was of Greg's intervention, but I gather it's about the maritime militia, basically private vessels carrying out conduct which is rather questionable and could be attributed to the government instead. No? And on that point, I agree completely with Rob on the characterization of militia vessels. The Philippines, particularly since has seen China's maritime militia vessels operating in conjunction with, under the coordination of the China Coast Guard, for example, in its operations against Philippine government vessels in its EEZ and continental shelf. So there seems to be no question there as to their intention and purpose. The problem that we see is that at the outset, using maritime militia vessels to conduct these kinds of government operations, there's an element of concealment, an attempt to conceal the nature of these vessels and their true purpose, especially if they're not yet involved in these particular operations. And the problem we see here in the Philippines is that these maritime militia vessels are spread all over the West Philippine Sea, and at any time can suddenly essentially change their colors or take away their cloaks and suddenly become government vessels. And this is, I think, a problem that creates uncertainty and instability in the South China Sea. And on the last intervention with respect to encouraging talks and discussions, I agree that is something that we need to do. And talks, after all, are the preferred peaceful modes of settling disputes. One problem I see, however, is that we also have to be conscious that it's not enough for us to be engaged in talks. The good faith of the party must also be manifested in its behavior while talks are ongoing. And this is where we have serious troubles, I think. No? While there are talks ongoing, such as the negotiations for the Code of Conduct in the South China Sea, actions are being taken, unilateral actions are being taken, which essentially either seek to create fait accompli or change the status quo or change the situation, which makes the talks essentially useless. And so good faith there is something that must accompany the talks, and self-restraint. No? While talks are ongoing, there should be no unilateral attempt to introduce changes in the status quo, which make these talks irrelevant. Okay, so probably I'll just stop there for now. Thank you.
Thank you, Professor. We are now right on the scheduled finish of this session. We have one question online, and to respect the online participants, I will invite the panelists to very briefly respond to it. But before we do that, and I apologize to those who would like to ask a question, I will take one question from the audience, but I will give preference to any woman who would like to ask a question, given that we haven't heard from women in this session yet. I can see you, sir. Okay, ask your question really briefly, then we'll take the online question and that'll be it. And I thank everyone for their forbearance. Please.
Thank you. Let me make a short comment on the presentation of Professor Yen Qian Chan. And you touch upon the obligation to prevent pollution. I'm from Japan's embassy in Vietnam. My name is Keisuke Nara. Sorry for forgetting introducing myself. And from the so Professor Yen Qian Chan touched upon the obligation to prevent pollution in any maritime areas. And in this context, the water, you also touch upon the water from Fukushima. But the discharge water from Fukushima, the Alps treated water, is consistent with international standard and custom. And Japan puts a top priority on safety, processing the water with a really strict criteria. So in addition, according to the Alps review, according to the IAEA review, the radioactive impact of the human and the environment are ignorable. So Japan wants to emphasize that it's not a problem of pollution in maritime areas. It's not appropriate to discuss this issue from this context. And Japan continuously provides information on the Alps treated water in good faith with a high degree of transparency while cooperating with IAEA and international community.
Thank you. I understand why you were keen to ask that question. And we have one question also from online, and then I'll give the panelists one last, very hopefully quick chance to respond. Medha Joshi from Kathmandu University asks, maritime areas such as the Arctic, undersea, unmanned vehicles, FNPP, etc., has not had fully developed law and has potential for grey activities. Is it more practical to come up with soft law, South China Sea focused first, while waiting for international law negotiation? So who would like to quickly respond, please?
I'll have a quick one and then my colleagues will undoubtedly want something to say. Meta, great question. I would say I don't fully agree that the law is not necessarily fully developed. I think one of the great things about the Law of the Sea Convention is that it has many principles in it which are fundamental and help us to understand how we might deal with things like floating nuclear power plants or unmanned vehicles, for example, uncrewed vehicles, I'm sorry. I think that there is fundamental principles that can help us do that. The second is, I don't think these are particularly suited to grey zone activities more than other tools. I actually think any tool, be it law or not, can be used as a grey zone activity. Third, is soft law useful? Soft law is useful, but I dare say that waiting for international law negotiation might be a problem. It's a fact of life right now that the ability to negotiate hard law, treaty law, is very difficult. And so in that respect, soft law fills a gap. But I guess a warning against soft law is unless there's a path to treaty rule or to evolution to customs, soft law is not necessarily the answer.
It's infuriating that I agree with him so much and I can't pick a fight, and I've been trying. First of all, let me just say about the lack of participation by women. I think it's completely our fault, gentlemen, and I mean all gentlemen, because of the title of this, right? A word invented by men for men, lawfare. Just bring all your toxic masculinity into it, even though all we're talking about is the deployment of law for political ends, which is what law has been deployed for since time immemorial. So perhaps that's our fault. We should have called the panel something else. Now, with respect to the question about underdeveloped law, first of all, I agree with Rob in the sense that you can apply a lot of principles by analogy. So is it really underdeveloped? That's one thing. Second, underdeveloped law gives you a potential for gray activities. No, even fully well-developed law will give you the potential for gray activities, as you will find out in the Aegean Sea, where there is very clear law with respect to islands, and yet a lot of it is grayed out. So you don't need, if somebody wants to gray something out, they'll gray it out. That's the whole point. So you can't avoid it. Is it then better to go for soft law, even accepting that this is the case, that there is underdeveloped law and so on and so forth? No, because soft law is not law. I don't understand. It's a contradiction in terms. You either have law or you don't have law. We can disagree about whether we have it or we don't have it. We can disagree about what it says, but what we can all agree on is that if something, you can't agree that something that you agreed on is actually not binding, because what have you done? In Greek, you would say you've done a hole in the water. And I invite you all to try making a hole in the water and see where that takes you. So I have issues with soft law. While we wait for negotiation, should we wait for negotiation? There is no need to wait for the negotiation. Even the graying out is actually conducive to creating the law, right? Law is not only made by negotiation and the adoption of treaties. Law is made by claim and counterclaim through the production of customary law that comes in and fills in whatever gaps the principles may have left, or whatever clarification is needed on the basis of the application of the principles. Now, that may sound a bit anarchic, but we are in a decentralized system, and this is how international law works. I mean, it is essentially the powerful that make the law. I'm sorry to break it to you, but it's exactly the same in the domestic legal order. I'm not sure why we're always shocked that it's like, oh, customary law, it's the powerful states that make the law. Well, duh. I mean, it's the powerful dudes that make the law in your domestic parliaments or whatever you have in reality. So I'm not even sure why we're so shocked by something that's pretty obvious, I think. But that doesn't mean that the weaker states cannot get together and sort of present a counterexample and a counterforce, but they do need to work together for that. Ding, ding, ASEAN. Thank you.
Thank you,
Let me quickly-
Antonios. Professor Gavin, would you like to add anything?
Yes, let me quickly just respond 2 points. Firstly, I was just saying MARPOL is designed to regulate pollution from ships. However, MARPOL does not address the issue of nuclear contaminated water. So we need to pay attention on this issue. That's the first point I would like to respond. Secondly, if like our audience say, Japan is fully compliant with the IAEA international standard, then why don't you keep this water within Japanese territory inland rather than just release it into the Pacific Ocean? So that's the second point I would like to make. Thank you.
Jay, would you like to have the final word?
Yes, thank you, thank you. Well, on this point about using soft law against the gray areas, no, I agree with Rob that it's not that there's any particular activity that's prone to being a gray zone or being subject to gray zone operations. Anything can be subject to these gray operations and become gray areas. All it requires really is the inventiveness of the state that's attempting to exploit a particular a loophole or gap in the law where the law isn't clear or there's no particular law that is squarely applicable. Is it advisable to use soft law? Well, I think the thing here is that soft law, if I recall correctly, one of the earliest writings on soft law identifies 3 particular categories. One is political statements and aspirations and documents that are issued by countries, by states, as the result of a diplomatic conference. So aspirational documents, those that state some kind of norms of behavior but are not legally binding. They're merely values to which they will aspire to. That's the first kind. The second is decisions of international organizations that have specific mandates and carry out their decisions in accordance with the agreed procedures. And so even though the decisions are not treaty norms, still the countries, the members of that international organization still comply with them. So that has been seen as another type of soft law. And then the third one is United Nations General Assembly resolutions and statements, given the particular status of the UN. And probably you could say that similar multilateral organizations and conventions with a particular status might be sources as well of soft law. Here within the South China Sea, welcome to the world of ASEAN, where soft law is the bread and butter of practically every meeting. No? And in a way, ASEAN has been preoccupied with the creation of these aspirational documents. And in many instances, they have worked in the sense that what we're doing is engaging in the process of community building through the establishment of norms and rules, that initially they may start off as being aspirational, but eventually they do harden into hard law or traditional treaty law. So maybe there is room for that, for these activities. The challenge really is being able to anticipate essentially particular issue areas where soft law will be needed in order to prevent abuses and disputes. So it's there, it's an option, but it probably requires a lot of thinking on the part of states. And again, also as with any other negotiation, any other activity on the part of states to create norms to live by, it requires a lot of good faith, really, and determination and commitment to act in accordance with those rules of behavior that they develop. Thank you.
Thank you, Jay. Will you all please join me in thanking our panelists? And I wish you all a good evening.
Yes. Sorry, we may just have done that. Yeah.
Thank you, distinguished moderators and our speakers, and thank you to all of you once again. That has been day 1 of the 15th South China Sea Conference. We'll be looking forward to seeing you tomorrow at 9 a.m. for day 2, featuring sessions on how to promote a greener South China Sea with sessions on the role of the law enforcement, the role of offshore energies, and also a very special sessions on the voice of the next young leader generations. And just a few admin notes before we let you go. First of all, for those who speak or understand or want to learn Vietnamese, don't forget to catch the live post sessions commentary, which is happening right now, right after this, with Dr. Nguyen Lan Huong from the East Sea Institute and honorable guest. Again, this is going to be in Vietnamese, no English translations, but the Facebook live stream and the YouTube live stream has the subtitle functions for you to review later. And for our on-site delegations, if you are going to join the dinner, if you have been invited for the dinner tonight, please see our receptions outside for the dinner coupon. And thank you once again, everyone. Thank you, our online participants, for your comments, your feedback, and especially your questions. Goodbye, everyone.